This is a screenshot video connected to our material on U.S. courts, the federal court system, New York courts, and then a little bit of material to let us know how trial courts differ from appellate, APPELLATE courts. And the first link that I put up and that I'm now looking at concerns essentially the federal court system. And I'm going to scroll down, and we see that there's three levels to the federal court system. The first level, if you will, and this is where cases start out and where they initially achieve a resolution, would be our district courts. And as noted in this link, there are 94 district courts in the country. Each state has from 1 to 4 district courts, depending upon population. Rhode Island, for example, has 1 district court. New York, on the other hand, given its large population, has 4 district courts. So in New York, by way of illustration, we have the Eastern District of New York, the Southern District of New York, and they're downstate. We have the Northern District of New York, which sits in Syracuse, but basically covers the northern part of the state and part of the southern tier. And then we have the Western District of New York, which is headquartered, if you will, in Buffalo, with 1 or 2 of the judges sometimes holding court in Rochester. If we were in a hypothetical law firm in downtown Buffalo, and if our representation of clients extended to representing clients in either civil or criminal federal court proceedings, the court we're likely going to would be the Western District of New York, or the U.S. District Court for the Western District of New York. And to give you a specific point of reference, it's a brand new building right off of Niagara Square, a few blocks away from ECC City Campus. Now, what we would see if we went over to the district courthouse and peeked into what was going on in the courtroom, if we were looking at the criminal cases, we would see that a defendant or defendants were charged with violating some federal criminal law. In other words, a law enacted by Congress, making it a crime, for example, to send contraband across state lines. If it was a civil case, what we might see is that the case involves a federal law question. A lot of our anti-discrimination laws, and thus the lawsuits that follow, are federal laws. Title VII of the 1964 Civil Rights Act that bans racial and gender discrimination. There's the Americans with Disabilities Act that bans certain forms of discrimination against those who are disabled. The Age Discrimination and Employment Act, which forbids age discrimination. What we would also possibly encounter in federal court looking at civil cases are cases that actually originate under the law of a state but end up in federal court because the parties are residents of different states and the amount in controversy is greater than $75,000. I'll say a little bit more about that when we talk about federal and state law. But for now, let's just be aware of the fact that we could see a case arising under state law being litigated in the district court. Now, when the case reaches some kind of conclusion, civil or criminal, in the district court, we may see an appeal. and that appeal goes to one of the 13 circuit courts of appeal in the United States. 12 of them, as it's noted, are organized geographically, and then there's a Court of Appeals for the Federal Circuit, which sits in Washington. But if we wanted to determine where we are, meaning those of us who are practicing law in Buffalo, we are in the Second Circuit, and that Second Circuit takes into account the district courts in Connecticut and not Vermont and New York State. So that's the Second Circuit. And just to take this a little bit further so we get a flavor, let's assume that we're representing a party in our hypothetical law firm who has an appeal to the U.S. Circuit Court of Appeals for the Second Circuit. We would eventually find ourselves traveling to New York City because that's where the Second Circuit sits, where a court gathers to do its business. We personify it often and say that's where the court sits. And that actually is located in lower Manhattan, not too far from where the Twin Towers had once been located. And what the authors tell us is that there can be any number of circuit judges in a given circuit, but when we actually appear in front of the court, only 3 of those judges are going to be on the panel, and those 3 judges will be the deciders of the appeal. There is a possibility, and we're seeing a little bit more today than we used to, even though the authors say it's a rare occasion. The loser in front of the 3-judge panel has the ability to at least to ask the entire number of judges on the circuit court to rehear a case, and that's called en banc, which I believe is a French term, but that is asking for a rehearing in front of the entire panel. Now we get to, as we work our way up the pyramid, though I'm scrolling down the page, as we work our way up the pyramid, we get to the U.S. Supreme Court, and aptly described as the highest court and final level of appeal. And I'm going to go back up just a little bit. And what our authors tell us is that we have a dual court system in the U.S. We have state courts and we have federal courts, though when they say state and federal matters are handled separately, don't forget I told you that a case under state law might properly end up in federal court. But if we're thinking of the Supreme Court, what we have to imagine is there's 9 judges on the court, and there are cases coming to the Supreme Court potentially from all of those 13 circuit courts of appeal at the federal system, but in addition, from 50 highest state courts where the losing party may believe that there's the type of issue that the Supreme Court has jurisdiction of. For example, a person may have been convicted of a state crime but have raised in the case a federal constitutional issue about maybe the propriety under the Fourth Amendment of a search and seizure. So the Supreme Court faces potentially a staggering number of cases that it could never possibly handle. But the saving grace for the Supreme Court is that it has, and I'm scrolling back down the system, it has the ability to choose the cases it hears. And typically how that happens is a party wishing to go to the Supreme Court is required first to ask the court to grant a writ of certiorari in the court, then either is going to grant the writ and schedule the case for argument and then proceed to a decision, or is far likely the case, the court's going to deny we call it a petition for a writ of certiorari. And as it's pointed out, there's no real standard of measurement as to how the Supreme Court selects the cases it's going to handle. It's up to the discretion of the judges, and 4 of the 9 judges must vote in favor to accept cases. And the authors are correct when they say typically the Supreme Court accepts cases where there are conflicting decisions coming out of the different lower circuit court of appeals, or is there a constitutional matter of national importance? But I think, in fairness, the constitutional matter of national importance is going to be significantly influenced by the political stance of at least 4 judges on the United States Supreme Court. So, by way of example, it seemed to a lot of us who were even casual viewers of the Supreme Court, once the so-called conservative judges reached a majority, the court wanted very much to accept a case for decision that sought to overrule Roe versus Wade and its holding that women had a constitutional right to abortion. I'm not suggesting that the court was wrong in accepting that case. I'm just saying practically what's considered of national importance is really going to be heavily dependent on politics. And this term, I think there's 2 other kinds of categories of cases the court has taken where it's going to reflect the conservative flavor of the majority of the court, and one will be affirmative action in terms of how it may be applied in selecting students for college admission, and another category is the amount of discretion given to federal administrative agencies. And I think there's a school of thought that the conservative members of the court think that too much discretion has been given, and they're going to try to curtail it. There's a long political, not improper, but political backstory that we really don't have the time or need to develop in this course. But this gives us at least an inkling of what the federal court system is about. And in the next screenshot video, I'm going to focus on the New York State court system. So that'll be it for this video. Thank you.